Hello everyone, I am Mukherjee, a student of Srinath Law College and interning with LEXIS and Company. Today I am going to talk about the basic structure doctrine, a very confusing and a very important topic about our constitution. The problem arises regarding the two articles, that is Article 13 and Article 368. While Article 13 tries to safeguard the fundamental rights and does not allow any laws to infringe them, Article 38 says about the amendment of the Constitution that is in the hands of the Parliament. To get a short view, Article 13 talks about the pre and the post-constitutional laws cannot be made such that it will infringe or take away the rights or the fundamental rights of the individuals. It cannot do so, and if it does so, then it will be void till the extent of the inconsistency it has with the fundamental rights. Also, the laws and laws in force have been explained under Article 13. We know that by the 24th Amendment, the article had a new clause introduced into it, that is Article 13, Clause 4, which told that this article will be not dealing with anything, any amendment that is brought under Article 368. Now the main question is whether any amendment comes under the purview of law as defined in Article 13. Article 368 talks about the procedures that the Parliament has to follow for the undergoing any amendment. Like it has to have a bill introduced in both the houses, it has to have the 2/3 majority, it has to have the states, half of the states ratification if it is taking into consideration anything in the 7th schedule or the articles as mentioned in Article 368. A new clause has been also added to Article 368 and by the 24th Amendment that also tells the same thing, that Article 13 will not have any effect on Article 368. Any amendment that is brought through Article 368 cannot be challenged. Now, continuously there is a conflict between the courts that whether the constitutional amendment should be thought as law or whether the Parliament was empowered to make any sorts of change, whether it abuses fundamental right and actually in a way change the entire constitution. So, to understand this problem, we will first talk about the first amendment that was brought about in 1951. Here, it was the Shankari Prasad versus the Union of India, where the Article 31A-B 9 schedule was introduced. And certain restrictions were also given under Article 19(1)G. Now, it was challenged before the court. Here, the court held that the Parliament can amend the Constitution and the amendment was absolutely valid. Under 368, they can even actually amend the fundamental rights. At that time, right to property was a fundamental right. Later, it was removed by the 44th Amendment. Now, after this, there was many other amendments like the 4th Amendment that actually again was affecting the fundamental rights. Again, during the 17th Amendment, certain other legislations were added to the 9th schedule and that created a lot of problem. Again, the court saw a challenge before it in Sajjan Singh versus State of Rajasthan. Here also, the courts told that whatever has been told in Shankari Prasad is well and good. But then came the case of Golaknath, where there was a 11 bench and it was decided in 6:5. In Golaknath, it was told that no, it cannot be done. Anything cannot be changed in the Constitution. It told that fundamental rights cannot be changed. And the Parliament is only given how the amendment can be made. They are not given any unlimited power under the Constitution. But it was also told that it will have prospective effect. Now, the Parliament was under problem and so they brought the 24th Amendment. again giving a wide range of powers to the Parliament. They added Article 13 Clause 4 and Article 368 Clause 3. Now this amendment was followed by several other amendments like the 25th Amendment that was talking about the property rights, 26th Amendment that was talking about the privy purse, and 29th Amendment that was actually bringing the land reforms under the 9th schedule. Now all of these were being challenged in Kesavananda Bharati versus State of Kerala. Here the main concept of basic structure came in, and the courts told that the Parliament has the authority to change the constitution's provisions, but subject to certain basic structure. Justice Sikri gave a list of basic structure, but it was not exhaustive, and it has to be decided on a case-to-case basis. Now, even after the Kesavananda Bharati case, we had seen the Vaman Rao case that decided that Kesavananda Bharati will only have prospective effect, no retrospective effect. Why? Because if it was not done in that manner, then a lot of problems, a lot of case will come. This was also preceded. Another case was also there, that was the Indira Gandhi versus Rajanarayan. That was after the Kesavananda Bharati judgment. In the 39th Amendment, the Parliament actually made that any elections cannot be tried in the Supreme Court, especially the elections of the President, Prime Minister, Vice President cannot be tried. Now the court held that here the power of judicial review was being challenged, and hence it was actually affecting the basic structure. This was the reason that the 39th Amendment was not valid. So the cases after the Kesavananda Bharati judgment actually followed the judgment, but it only told that it has a prospective effect and not a retrospective one. It was mainly done because of the fact that if all the other judgments are being, all the other amendments are being questioned before the court, all the judgment before Kesavananda Bharati, then it will lead to a lot of chaos, and hence this thing was decided in Vaman Rao. And this is a very short view of the basic structure doctrine that forms the heart of constitutional law. See you all. That's all for today. Thank you.